Hello students, welcome back to studies. In this video, we will discuss the essential elements of a valid contract. Now for any contract, we already know the definition of contract. All agreements which are enforceable by law are called as contracts. But for an agreement, there should be an offer and there should be its acceptance. So necessarily there should be two parties, one of the party making the offer and the other party accepting it. Now the offer that is being made has to be in definite terms. There should not be ambiguity in the terms of the offer. It should be clear, it should be precise. And likewise, acceptance also should be unconditional acceptance, and the acceptance has to be definite. It should be for the offer. Whatever acceptance is given by the offeree, it has to be absolute and unconditional. Technically, there are two parties. One of the party is the offerer and the other party is the offeree. Now, who is the offerer? The party who makes the offer, who places the offer is called as the offerer, and the party who to whom the offer is being made is called as the offeree. Now, as soon as the offeree accepts this particular offer, then he will be called as the acceptor. Okay, so once acceptance is done to the offer that is being made by the offerer, the offeree will now be called as the acceptor. Okay, so the offer that is being made has to be in definite terms. It has to have a very clear cut, and it has to be clear cut and it has to be precise. And the acceptance should be absolute acceptance, absolute in the sense whatever the offer is being made, for that acceptance has to be given, and the acceptance has to be unconditional. Also, the acceptance has to be made in the mode prescribed. So, if the offerer says that the acceptance has to be made through an email, in that case, the acceptance has to be done through an email. Okay. So, if a specific mode of acceptance is prescribed, it is the duty of the acceptor to give his acceptance in the specified format. The second essential element of a valid contract is intention to create legal relationship. We have already seen in the first video that when it comes to a contract, it is not just the agreements, okay, it has to be enforceable by law. That means to say the parties, offerer and the offeree, should have an intention to create legal relationship. Now agreements can also be social agreements. Okay, if it is a social agreement, then it is not enforceable by law. For example, if A is inviting B for his wedding and B spends his money and time and travels to witness the wedding of A, but if the wedding is cancelled, in such cases B cannot file a case against A because it comes under the purview of a social agreement. Okay, so there is no, when an invitation is made to attend a wedding or an invitation is given for any social gathering, the intention between the parties is not to create any legal relationship. Okay, so one of the essential element of a valid contract is that there should be an intention to create legal relationship. Another essential element of a valid contract is there should be a lawful consideration. Now, what is consideration? Something that is given and received. So both the parties to the contract should, both the offerer as well as the offeree should give something and get something in return. For example, in case if A agrees to sell his car to B for rupees 3 lakhs, in this case, A is the offerer and B is the offeree. So what does A get? A gets rupees 3 lakhs and in return he gives his car. What does B get? He gets car and in return he gives rupees 3 lakhs. So both the parties should give something and get something in return. This something that is received and given is what is called as consideration, and this consideration should be lawful consideration. Say if this particular sale is for smuggled goods. Okay, in case if it is for smuggled goods, in this case the consideration is smuggled goods, as such it is not a lawful consideration. Fine. So one of the essential element of a valid contract is that there should be a lawful consideration. Also, for a contract to be a valid contract, the parties to the contract should have the capacity to enter into contracts. They should have the competency to enter into contracts. Now we have offerer and the offeree as the parties to the contract, both these parties should have the capacity to enter into contract. Now, who are the parties who have got the capacity to enter into contracts? Give me a minute, let me clear this. So the parties who do not have the competency to enter into contracts are minors. So if one of the party is a minor, that means to say there is no valid contract because one of the party lacks competency to enter into contract. Likewise, in case if a person is an alien enemy, okay, he is a national of an enemy country, in that case also he does not have the capacity to enter into contracts. Suppose in case if the person is intoxicated and he is intoxicated to such an extent that he does not understand the terms of the contract, okay, suppose if he is drunk to an extent that he does not understand what the terms of the contract um, is, in that case we say that he does not have the capacity to enter into contracts. Likewise, insolvents. Insolvents are the ones who have been, now the insolvency is declared by the court of law. So insolvents are the ones who have more of liabilities than their assets. Okay, so in case if the court declares an individual as an insolvent, as soon as he is declared as an insolvent, he loses his competency to enter into any of the contracts. It is not that insolvency is permanent. As soon as he once again becomes as solvent, once again if the court removes his insolvency status, in that case after he being relieved from this insolvency status, he will be capable of entering into contracts. Also convicts, okay, criminals who have been convicted by the court of law, during the time they are serving the sentence, they do not have the competency to enter into contract. Okay, so one of the essential element of a valid contract is that the both the parties to the contract, it is not one of the parties, both the parties to the contract should be competent to enter into contract. Another essential element of a valid contract is that the consent that is given, consent is, we are talking about acceptance, the consent that is given by the offeree should be free and it should be genuine. Now what do you mean by free consent? Now free consent in the sense, whenever the acceptance is given by the offeree, this acceptance should not be forceful. He has to give this give his consent, give his acceptance willingly, okay, or from his he should exercise free will when he is giving his acceptance to the contract. Okay, now if in case if there is coercion, coercion means putting pressure on the individual and getting his acceptance, or in case if there is if the acceptance is given by mistake, or if there is acceptance that is given by way of misrepresentation, or in case if there is undue influence, in all these cases the consent is not free. Okay, so one of the essential elements of a valid contract is that the consent has to be free and the consent has to be a genuine consent. The next essential element of a valid contract is that there should be a lawful object. The object for which the contract is entered into, the reason behind entering into a contract has to be a legal one, and it has to be moral, morally right. The reason, the object behind the contract should not be an illegal one. Like, for example, sale of arms and ammunitions. Definitely, it will be the object of the contract itself is illegal. Uh, in case if the house is rented for prostitution work, now this also has got an object. The reasoning behind it, the reason behind the contract is immoral. Okay, but there are countries which has made prostitution a legal profession, but then in case if it is not a legal profession, if it is not given the status of a legal profession, then definitely it will be treated as the object of the contract turns out to be an immoral one. It should not be opposed to any public policy in the sense, like for example, public titles that are given, like Padma Bhushan, or the highest civilian awards that are given, or maybe or the Paramveer Chakra, etc. All these are given for the work that is done by the individual, and these types of awards should not be purchased, or it should not be bribed and purchased. Okay, in case if it is done so, then it is opposed to public policy. Okay, another example for agreements which are opposed to public policy is agreeing to commit a crime. Now, that is also the object behind the contract is opposed to public policy. It is illegal. As such, it turns out to be a contract which is not valid in the eyes of law. Another essential element of a valid contract is that these agreements should not be expressly declared as void by any of the laws that are in force in the country. Okay. For example, tomorrow if the government comes up with a ban on private trading of, let us say, sugar, in that case, it turns out to be any agreements which are for the purchase and sale of sugar by private parties turns out to be an agreement which is expressly declared void because the ban has been brought up by the government. Yet another essential element of a valid contract is that the agreements have to be certain and it has to be possible to be performed. For example, in case if the dealing is for purchase and sale of a car, okay, and no other information about the car is given, that means there is no certainty in this particular contract. Okay, so the contract the agreement is very vague. Okay, there is no proper description of the consideration, there is no proper description of the commodity that is being exchanged, so certainty is lacking in this case. Okay, and also the agreement should be possible to be performed. If in case if the agreement is to sell a magical carpet, definitely there is nothing like a magical carpet, right? So in this case, the agreement is impossible to be performed. All these agreements should be certain. It has should be in definite terms. There should not be ambiguity, and it should be possible to be performed. Another essential element of a valid contract is legal formalities. There are certain contracts which has to have a specific, formalities, legal formalities that has to be taken care of. In that context, those contracts will be valid only in case if all those legal formalities are adhered to. For example, some of the documents have to be written only in stamp paper. It has to be signed and sealed. There should be witnesses. It has to be stamped. So wherever there is legal specific legal formalities that has to be taken care of, it has to be adhered to. But one thing we need to remember over here, the contract can be made either by words spoken orally, or it can be written as well. Okay, so there is no per se there is no difference in the legal effects whether the contract is in writing or whether it is made orally or by word of mouth. Okay, but it is always better whenever we talk in terms of in a business context, it is always better to have the contracts in writing so that there is proper documentation, and in case if there is any dispute that arises on a later date, you have all the proofs that can be presented in the court of law to prove your point. Okay, so students, these are the essential elements of a valid contract. That's all for now. I'll see you all in the next video. Hope you all had a pleasant learning experience. Thank you.